If you have a felony case in California, your attorney might have mentioned something called a preliminary hearing and explained that that is where the witnesses, including the alleged victim, if there is one, will show up and testify, and your attorney will get a chance to cross-examine them. One of the questions you might have is, but what happens if the alleged victim does not show up? And in this video, I'm going to be discussing 3 different implications if the alleged victim does not show up. My name is Veronica. I'm a criminal defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be answering the question, what happens if the alleged victim does not show up in a preliminary hearing? And not just alleged victim, I primarily do domestic violence, so that's what I'm used to saying and explaining. But if there's a key witness, if they don't show up, let's say it is a vandalism case, and there's one person who saw you allegedly graffitiing the side of a wall. What happens if that person doesn't show up? And usually, by the way, that would be a misdemeanor, but if they add a gang allegation or something, then maybe it's a felony. So very briefly, I do have a video already on what a preliminary hearing is, but if this is the only video you're going to watch and you're wondering what I'm even talking about with a preliminary hearing and your attorney maybe didn't explain, really briefly, let me explain. A preliminary hearing is also called a probable cause hearing, and in the state of California, what this is a hearing where the prosecution must present evidence to the judge, and evidence in the form of witnesses and then sometimes exhibits, meaning actual evidence, video, photos, etc., through a witness to the judge to show that they have enough evidence to proceed. By enough evidence, I mean that there has to be probable cause. And by probable cause, I mean that a reasonable person would believe that a crime was probably committed and that you probably committed it. Probable cause is the same standard as the standard to arrest someone. Obviously, people get arrested for things that they didn't do every day. It is a very low standard. It is not the same standard that will apply if you actually go to trial in the case. If you go to trial, the standard will be beyond a reasonable doubt, which is very high, the highest that we have in law, and is much, much, much higher than probable cause. Okay, so let's jump right in. The 3 implications of the witness not showing up, the key witness, the alleged victim, not showing up for your preliminary hearing. Number 1, if the alleged victim, if the key witness does not show up for whatever reason, generally what will happen is that a police officer will testify instead of that person and will be able to basically regurgitate the police report. In 1990, and I promise I won't get too far into the weeds with the legal history or other nerdy stuff here, but in 1990, a law passed allowing police officers to testify instead of the alleged victim or the key witnesses actually testifying. So what they're allowed to do is basically, and what they actually do, is they read the police report right before they go on the stand. Maybe it's been many months and they don't actually really have any memory of it, and they testify as to what each witness said. This is allowed only because of this law. In general, and this is not allowed at trial, by the way, in general, this would be hearsay, which is an out-of-court statement. You can't basically just go on the stand, and there are exceptions to this. There's a whole very complicated class in law school devoted to this, but basically you can't go on the stand and testify as to what somebody else told you to prove that whatever they told you is true. They're not there, we can't see them, we can't evaluate how truthful they are, right? So in general, that's not allowed, and at trial this wouldn't be allowed, but that is allowed for preliminary hearings. And you can thank voters for voting Prop 115 into law in 1990 for that. Now, the good thing about this is that if the witness is also not available for trial, they don't show up for trial if it gets that far, then their testimony just won't come in at all, because at that point, the police officer will not be able to get on the stand and say whatever the victim said or the witness said when the police went out there originally. They won't be able to do that. So at trial, the case might be dismissed. Now, let's say that the witness, the alleged victim, did show up for the preliminary hearing, did testify, and then the judge deemed that person unavailable for trial. Like, they showed up for the prelim, but then they disappeared. Probably in that case, and by the way, prelim is a nickname for a preliminary hearing, so if I say that or if you hear that in court, that is what I mean. That is what we call it. If the witness showed up for the preliminary hearing but did not show up for trial and was deemed unavailable, then the prosecutor might be able to bring their testimony from the preliminary hearing into evidence at trial, which is not good because your attorney can't even cross-examine them there. So if they don't show up for the preliminary hearing, then that's not a possibility. You eliminate that risk. Okay, and why this is a bad thing, though, is that it's useless for your attorney to cross-examine the police officer based on what is in the police report. What they're going to say if the attorney asks for more details is they don't know. That wasn't in the report. They don't know. The witness's credibility really isn't in question here. We can't get more information than whatever was in the report, which is a big problem because that's one of the things you want to use the preliminary hearing for as a defense. Now, to the credit, and you won't hear me say anything like this often, but to the credit of the district attorney's offices in California, they generally do try to get the witnesses there, try to get the alleged victims there. Part of the reason why is that even though it might seem like there's this DA who's working really hard to build a case against you, usually they're not talking that much to the alleged victim, to the witness, unless they actually have a hearing. They're not really sure about how credible they are. So your defense attorney maybe is interviewing you and trying to assess how credible you will come off to a jury or to a judge in advance. But really, the DAs aren't doing that. They are busy. They are in court every single day. So unless the witness or the alleged victim actually goes on the stand and is subject to the DA's questions, cross-examination from the defense attorney, they really can't fully evaluate the case. So the DAs try really hard to get them here. They do try to subpoena them all. They could be lazy. They could strategically decide that they are just going to use police officers for this, but they don't. But the bad thing about them ending up using the police officer and having the police officer testify is that you will really not be able to cross-examine them. Your attorney will not be able to nail them down to their testimony. They said something to police. Hopefully there's body-worn video of that, but your attorney really wants to nail them down. This is probably your attorney's one chance before trial to ask them questions, so we want them to be there. I prefer if they're there in general. Number 2. If the witness was served, the witness or alleged victim was actually served with a subpoena. So it's generally a sheriff's deputy who will go out and try to serve them with a subpoena and find them and actually hand them a subpoena, drop it at their feet, find them at their work or their home. If they were actually served with a subpoena, then a warrant could be issued if they fail to appear. Now, this only applies if they were actually served. But what you might be wondering is, will that help my case? Okay, well, on the one hand, as I said, I prefer to have the victim there and be able to cross-examine them. I don't want to go into a trial without a transcript of what they said before, without the chance to ask whatever questions I have, because one of the cardinal rules of cross-examination is don't ask a question you don't know the answer to. So I want to have had my chance to ask those questions with no risk during the preliminary hearing. However, if the prosecution and the sheriff's deputies are completely unable to serve the victim and get them to show up, what does that tell them? It tells them that for trial, they may have the same issue. So it could actually help you if they are totally unable to find this person. Now, how much does that matter? Well, it really depends. What other evidence do they have? So I gave you the example of graffiti. So let's say that the witness who saw you actually spray painting your name and a smiley face on the side of a wall doesn't show up. But when you were stopped by police, it was blue spray paint. You had blue spray paint all over your hands. The graffiti was your first and last name, and the graffiti was still wet. Well, they might not really need that witness all that much. They might still be able to convict you. It really depends. But if they are really relying on the testimony of that witness and they can't get them there, and they know that they probably can't get them there depending on what happened when they tried to serve them with a subpoena, then it's possible. And I don't want you to think that this is a really likely possibility. It happens rarely. It's possible that they will say that they are unable to proceed with the case and dismiss it. Now, I will tell you, I've had this happen very rarely in my career where for this reason they decide to dismiss it at this point. On one of the occasions, just to give you an example, they tried to serve the alleged victim with a subpoena. They'd been totally unable to contact her, and it turns out that she had gone back to Mexico according to her family and her neighbors and was not intending to ever come back. So they knew at that point that it was very unlikely that they were going to be able to proceed with the case. It depends on the client too. If that client had been a gang member with multiple strikes on on his record and a long history of criminal activity, then maybe they would have kept the case open. Maybe they would have tried harder. Maybe they would have waited to see if she came back and just gone with a police officer testifying. But in that case, that client had no criminal history, and they only have so many resources. So in some cases, they will then decide that they are not able to proceed, and they will actually dismiss the case. But be cautious of that, because I know when you hear that, you have this thread of hope that maybe the case will be dismissed. Be very cautious with that, because if they are able to, and it depends on the case, and it depends on you too, and your criminal history, it depends how serious the case is. But if that person, let's say, comes back from Mexico and the statute of limitations has not run out, maybe it's only been a few months, not toward the end of the statute of limitations, and says, hello, my neighbors told me that you guys were trying to serve me. I'm here. I'm willing to testify. That was a really horrible thing that happened to me, and I want to testify. I support this case. They can refile against you. When your case gets dismissed, bond gets exonerated, meaning if you posted your own bail, like you posted the actual full dollar amount, if it was $50,000, you actually posted $50,000 with the court, you'll get all that back. If you had a bail bondsman do it, which is what most people do, and you paid them on $50,000, $5,000, they get their money back. But if the case gets refiled, you are probably going to have to post bond again, and you generally do not get a refund of that amount. So if this is something really temporary where the victim happens to be unavailable, in the hospital, on vacation or something, and is likely to want the case to proceed and contact the prosecution in the future, or if it's a really serious case, or you have really bad criminal history, they might refile it. So if you already posted the bail, then that can be a very big problem for you, especially if you don't have the other $5,000 anymore. If you don't have an additional $5,000 and it was hard for you to come up with the first amount, that can be a big problem for you. Number 3, the preliminary hearing will probably be continued to another day, whether you like it or not. Generally, when these preliminary hearing dates are set, they are set as 0 of 10. That means that the prosecution has 10 court days from that day to be ready. So let's say that they just completely failed to bring the police officers, they forgot to contact them, or the police officers are busy, or they completely forgot to subpoena the witness, they have nobody there, they can't proceed. They're going to have more time. They automatically have more time. Generally, these preliminary hearings, the initial date at least, is not going to be set as the last possible day for them to have the preliminary hearing. Plus, as I mentioned, let's say that the clock ran out. If they dismiss it, they can still refile. And if you already posted bail, you might have to repost it. So it's not necessarily a good thing. Also, let's say that they actually do get to the very last day. It's day 10 of 10, meaning that this is their final day to possibly have the preliminary hearing. If they can demonstrate to the judge that they have good cause, like basically the witness, the police officer, they're not there and there's a good reason for it, then the prelim will be continued anyway. Probably not for a very long time, but it will be continued. And by continued, I mean rescheduled for another day. But also remember that as the defense, and I'm speaking in general terms here, this is all on a case-by-case basis, but as the defense, we usually want the witness there so that we can question them, so that we can have a transcript, so that if at trial they say something different than they said at the preliminary hearing, then we can get them and we can attack their credibility. If we have questions for the witness that we want to ask before trial, because at the preliminary hearing, it's not really a show. The judge is probably going to, no pun intended, probably going to find that there is probable cause. They do in almost every case, unless there's really almost nothing that the prosecution presents about a certain fact or element that's required for the crime. There's no danger of asking, why did you do something, and having the witness give a really good reason. That there is, in front of the jury, we want everything to be carefully curated as much as possible. And so I want to work out all the kinks while I can at the preliminary hearing. That's not really what it's supposed to be for, but as a defense attorney, that's something that I want to do as much as the prosecutor and the judge will allow me to do, so that my client has the best possible chance of winning at trial. And I mean, another thing that I might want to do is, if I can ask the witness these questions and they don't have good answers, and let's say that the prosecutor before the preliminary hearing really wasn't willing to give me what I and my client want for my client, then after the preliminary hearing, I can talk to the prosecutor again and say, hey, look, that didn't go probably as well as you had hoped, and you know at trial you're probably not going to win, but hey, my client is still willing to offer, for example, classes in exchange for a dismissal, and try again. I hope you found this video helpful. If you did, please don't forget to like, subscribe, and ring the bell. And if you do find yourself in this situation where you do have a preliminary hearing coming up, maybe nobody did explain any of these things to you and you want a consultation, feel free to book a call with my firm. You can find the link down below. You can also find our number there.